Hi, I'm Mark Turner, a partner in the Planning, Environmental, Energy and Regulatory team at Aaron & Partners Solicitors, and today I'm going to be answering 5 common questions about planning law and the rural economy. They should be aware of the ability to sell off-site BNG units to developers, which gives them an opportunity to diversify or use land that isn't great for farming or food production, or just to have an additional income stream. There's a lot to think about for landowners, particularly whether they do the works and sell the units themselves, or whether they partner up with a company who will do that for them. You can, but you would need planning permission generally for that sort of change of use, and the prospects of getting permission will depend on the nature of the scheme and the locality, so nearby neighbours, proximity to a settlement, that sort of thing. There are some permitted development rights for these sorts of changes of use, which are set out in the permitted development order. There are a huge number of conditions that need to be met in order to benefit from those. So it's important to be clear on those before actually doing the work. So permitted development rights are effectively a national grant of planning permission for works which would normally require planning permission to be obtained. There are different versions of the permitted development order in England and Wales, so it's important to be clear that you're looking at the right version. And for most permitted development rights, there are a huge number of conditions and requirements that need to be met in order to benefit from the right. So again, really important to be clear on those, and really sensible to get what's called a certificate of lawfulness before carrying out any works to get formal confirmation from the local authority. One of the major pitfalls of permitted development rights is that the rules aren't totally clear and can be open to interpretation. So one of the risks is that a landowner or developer decides for themselves that their works comply with the permitted development order and carry them out, and the local authority thinks that they don't and takes enforcement action. One way of getting around that, or being sure that the works that you're doing comply, is to seek a certificate of lawfulness before work starts. For solar farms, yes, you can use the land only for sheep grazing, although the consensus is that generally the grass doesn't grow anywhere near as well under the panels as it would without them. For wind farms, you can use the land which is not developed as it was effectively before the wind farm was developed, but obviously those parts of the land that are developed with turbines and other associated development can't be used.